when you get arrested, for most people, it's a situation you've never encountered before, and that is you've lost your freedom. You will be kept in a cell when you're arrested, and the reason that you hear that cold steel door close, and the reason they keep you there for 5 or 6 or 7 hours explaining to you that some computer is down, which of course is almost never down, is because they want you to have a time to reflect that something is really different in your life. When they do the paperwork on you, the last thing they do is to prepare the charging instrument. They know what they're charging you with when you walk from the jail. They're supposed to give you a copy of that document. They usually don't in Cook County. When you have your first court appearance, it's called an arraignment, and something magical happens in the law at that point. The charge is, you are confronted with the charge against you. You have a right to demand it actually be read to you, although very few people do. And at that point, having been confronted with the charge, if you fail to show up in court, you can be tried in absentia. What normally happens at arraignment is you'll normally enter a plea, although that isn't required. It should be a plea of not guilty unless the case is going to be disposed of that very day. The second thing that should happen is your lawyer should file a request for discovery, a written request for discovery, so you get to see the evidence against you. Just because you've been arrested does not mean that you are convicted. An arrest or an indictment is not a conviction. There will be lots of pressure on a prostitution defendant to enter a plea on the first day you're in court, on the day when you haven't even seen the police reports, when your lawyer hasn't seen the police reports, to get it over with so you don't have to come back in court. That's almost always a mistake. Lots of misrepresentations will be told to prostitution defendants, unfortunately, sometimes by their own lawyers. Not every lawyer is the knight in shining armor who is fighting courageously. Some of them are doing it for a $100 fee because they're the Chicago Bar Association attorney in the courtroom and they make their money on volume. Sometimes it's an overworked public defender who simply wants to get through the day and get home to whatever that public defender does. Sometimes you have to make a command decision. You are the client. You're in charge. Any lawyer who works for you, whether you're paying him or whether the county is paying for him, is someone who works for you. Ultimately, no lawyer can make the decision on whether you plead guilty, whether you take the stand, whether there's going to be a trial, whether there's going to be a jury trial. And you have to make those decisions as intelligently as you can, as smartly as you can. Any lawyer who's advocating for you should walk into the courtroom with the presumption they're going to plead you not guilty and there's going to be a trial. Let me emphasize that. The lawyer who represents you has got to go into it believing and assuming that you're probably incapable of being convicted of it and the case is worth fighting. A lawyer should only change his mind and change his advice to you on a plea after there's been a complete examination of all the evidence and it looks like fighting the case will be absolutely futile and nothing is to be gained. What you have to keep in mind is this. If you have no prior conviction in Cook County, there's very little to lose by trying your case. There's a presumption in Illinois law that people who have never been convicted of an offense before in a misdemeanor should get supervision unless there's a compelling reason why they shouldn't get supervision. And in Illinois, a supervision is not a conviction. A supervision is expungible, while most convictions are not expungible. In other words, there is a way of getting the record of the court proceedings and of the arrest obliterated. And that will be the same in most cases, whether you plead guilty or whether you fight it. There is almost no advantage ever in a first-time offender in accepting a deal for supervision on a guilty plea, because that's pretty much what you're going to get if you fight the case and you lose it. They'll tell you that supervision is nothing. Well, supervision is something. Otherwise, they wouldn't be bargaining for you to plead guilty and promising to give it to you. When you have supervision, number one, until or unless it gets expunged, there's a record that you've had a prior supervision. And that means if you get in trouble again, they're going to say, well, we tried supervision. Now this person deserves a conviction. We're not even going to afford them an opportunity to get supervision because they've had that before and it didn't work and they got in trouble again. So you're no longer at square one. You've got to fight the case. And understand this, you have a right to be acquitted unless by legal and competent evidence beyond reasonable doubt The state has proven all of the elements of the offense. It is your right to be acquitted if they don't prove all of the elements of prostitution by legal and competent evidence beyond a reasonable doubt. And that can be harder to prove than you might believe when you first see the case. A few years ago, a young lady came to me from the south suburbs of Chicago, charged with prostitution in an undercover sting operated by the Cook County Sheriff's Police. The Cook County Sheriff's Police set up in a hotel on River Road, and they called about 60 or 70 escorts, and unbeknownst to the escorts, there was a camera running in the room, no video, no audio, just video, and the undercover officer had a prearranged signal. When he thought he had a prosecutable case for prostitution, he would do something on camera, and then all of his accomplices, all of his backup crew would come into the room. And there was a videotape showing this young lady entering the room, being paid some amount of money, doing a little dance for the undercover cop who was sitting in a chair, removing her clothing, bending down, touching her toes with her butt in the guy's face. The prearranged signal was given at that point, and all the backup came into the room, and she was arrested and charged with prostitution. We had the trial in this case 7 months later. I'd spent an entire weekend living with that videotape, and I knew it intimately. The police officer probably hadn't looked at the videotape at all, and when he took the stand, I cut him up like with a machete on the stand because his recollections did not track at all with what was on the videotape. My client took the stand, and she said, yeah, I'm an escort. I agree, I don't deny that, but you know what? I never agreed to any particular sexual act with this guy for any particular sum of money. I was scared because not only did we have a judge up there, but we had some citizen court observer who looked like he was a distinguished World War II veteran, a veritable bastion of moral rectitude, watching the judge. We got an acquittal in that case. The judge found my client not guilty. What you have to understand is this. It's always the government's burden to prove its case by legal and competent evidence beyond a reasonable doubt. But sometimes judges don't always pay full attention to the gravity and the importance of that standard. They almost always do in prostitution cases, because judges understand that a prostitution conviction on a female is equivalent to child molestation or rape on a male. It destroys someone's character in the community. The worst thing you can call a girl on the playground in junior high is a whore or a slut. And we all know that, and we grow up with it. Once someone's been convicted of prostitution, people have a right to call her a whore and a slut, and she can't sue for libel or defamation or do anything about it. And judges understand that, and they are reluctant to put that lifelong onus on a person unless the case has been proven as the law requires by legal and competent evidence beyond a reasonable doubt. When I was in college in the mid-'70s, Playboy magazine ran a series of articles about sex in major American cities, and one of the articles was called Sex in Chicago. This ran probably in 1975 or 1976. And I'll never forget the words that this article began with. The article began with, anyone who is serious about sex in Chicago goes to New York for the weekend. Chicago is a fundamentally conservative city, and there's no question of it. Chicago is one of the few cities in the country that is aggressive about using undercover decoys to arrest escorts. And they regularly troll all of the escort advertising pages that exist. You can't pretend that it's not illegal, because it is. If you get arrested for this kind of activity, immediately get an attorney. Say nothing. Understand this. If they're asking you questions, that means they don't have everything they need. I want to repeat that. If they're asking you any kind of questions, that's a telegraph signal to you that they need more information to get your butt locked down. So do not answer any of their questions and get an attorney immediately. With respect to lots of other issues, our practice includes representing people who make porn, and if you're involved in the production of adult content materials, it is absolutely lunacy to do this without a lawyer working with you closely, both because of issues of prostitution, rights, issues concerning the rights of models, copyright, is a federal statute, 18 U.S. Code 2257. You need to be working with an attorney if you're involved in any aspect of the adult entertainment industry, period.